Cigna is a known offender. They entered into a multi-state agreement and said they wouldn't use the same old liar-for-hire experts that gave Cigna medical and vocational opinions they used to justify a claims denial. Did they learn? Did they go back to their old ways? How can you find out if your claim has been denied using their tired methods of claims denial? I'm ERISA Disability Insurance Attorney Nancy Cavey. When a claim is denied and a denied policyholder has exhausted their appeals, the only recourse is to file a lawsuit in federal court. The judge is normally limited to what was in the carrier's file at the time of the last denial. So how do we get the judge to look behind that curtain and find out if the carrier is self-dealing? We file what's called discovery requests for information and documents that can prove that the carrier is self-dealing. Now, it can be very difficult to get a federal court to allow discovery in an ERISA case. ERISA disability carriers fight like crazy to limit what information a denied policyholder can obtain and submit to the court outside of what's in the carrier's file at the time of the denial. So let me tell you about Cigna and how they got caught. Cigna is no exception to the carrier's fight about discovery. What makes the case of Jones versus Life Insurance Company of North America so unique is how one federal judge called Cigna out on its history of self-dealing with its vendors and experts in discovery. As an ERISA attorney, I would love to know the following things. How many times has a disability carrier used industry vendors like GenX, ECN, or MES Solutions? How much does a disability carrier pay vendors like GenX, ECN, or MES Solutions? How many times does a disability carrier use paper reviewers like Drs. Kalp, Bellecourt, and Cohn, all of whom are well-known players for disability peer review companies and disability carriers? The number of times the disability peer review companies and paper review doctors have concluded that the policyholder could work. What guidelines and manuals the disability carrier used in evaluating a claim. The list can go on and on and on. But only in limited circumstances do federal judges require that the disability carriers answer these questions. The Jones court recognized that Jones, who had been paid benefits for 5 years, was denied after Cigna, Lena, began a spontaneous review and found he was no longer disabled. The denial was based solely on a paper review by the tried and true disability insurance vendors and experts who are paid to give the disability carrier a reason to deny the claim. When presented with diametrically opposed expert reports, the court recognized that the credibility, the bias, or prejudice of the experts is relevant, and that's particularly true where an expert or the third-party vendor who supplies the expert has a long-standing relationship with or who receives substantial compensation from a carrier or industry and overwhelmingly issues favorable opinions to the insurance company. That's important as you assess bias and credibility. Lina will now have to answer questions about whether they have a structural incentive to minimize benefit payments and distorts its obligation to fairly handle benefit claims as a result of the use of vendors and experts who rely on Lina for their livelihood. I've helped thousands of ERISA disability policyholders across the United States, including Cigna policyholders just like you. If you have questions about a claims denial, filing an appeal of a wrongfully denied claim, or suing that disability carrier in federal court, call my office immediately for a free consultation at 727-894-3188. Don't let the disability carrier rob you of your peace of mind. Make the call, Cavey Law.